regular September meeting of the Concord Zoning Board of Adjustment. We will be following our usual procedure this evening, which is to say we will take the cases in the order in which they appear in the agenda. We will ask the appellant to come forward and present whatever he or she would like us to hear. We do ask that the appellants confine themselves, if at all possible, to 10 minutes of testimony. Following that, we will solicit testimony from anyone in the audience who is in favor of the appeal and anyone from the audience who is in opposition to the appeal. We ask that those who testify from the audience try their very best to confine their testimony to 5-minute intervals. After that, we will check in with code enforcement to see if there is anything that the office has to offer to the information on the case. And then, if any information has come forth that seems to bear factual clarification, we will offer the appellant the opportunity to provide that clarification, not new evidence, prior to our closing the public testimony portion of the hearing. At that point, the board, under most circumstances, will act on each case before moving on to the next one. We do have one case that we are going to be opening and adjourning immediately tonight, and that is case 5121, John J. Flatley Company. That case will not be heard this evening. We will be hearing that case in 1 month. So I will declare case 5121, John J. Flatley Company, open, and I will entertain a motion to recess the case till the next meeting.
So moved.
Is there a second?
Second.
Any discussion? All in favor?
Aye.
Anyone opposed? The vote is unanimous. Case 5121 is recessed until next meeting and will not be heard this evening. Which brings us back to the top of the agenda, and that is case 3921, ECR PDK LLC. This is a recessed hearing. The applicant requests that the board overturn the code administrator's decision that the subject property must comply with Article 2877G2 and rule that the subject property may have a non-conforming parking spot in the setback area on its southerly side for a property located at 46 North State Street in a CVP Civic Performance District. Do I hear a motion to reopen this case?
So moved.
Is there a second?
A second.
Any discussion? All in favor?
Aye.
The case is reopened. Mr. Meckel, are you ready to go?
Thank you, Mr. Chairman.
Mr. Chairman,
Yes.
would you like to appoint me to sit on this?
I don't think I have to.
No? Okay.
No. No, you're it.
Okay.
May I swear you in?
Yes, sir.
Swear to tell the truth and nothing but.
I do.
Thank you very much.
While we're at it, I have a witness here under subpoena. Attorney Steve Goldman, can we swear him in now?
Sure.
Or do you want easier to do it?
Under subpoena, my goodness. I don't think that's ever happened. I'm not leaving.
That's it. I'm
I
done.
am intimidated, but I'm not.
Is Fritz's right up in your packet?
No, all I have is the application.
Yeah, I thought he.
Yeah, but that comes from the abutter, right? Yeah.
I have a handout, Mr. Chairman. May I approach?
Yes, please.
I didn't get last month's back.
Thank you.
Fritz, you submitted something in writing, right?
I do.
Yeah, I remember seeing it, but it's not in this month's packet.
You don't happen to attach a copy of that to this, do you?
I didn't.
Okay.
I assume
No.
you all had a copy.
Nope. Nope.
We don't, Attorney Mokel had written, I remember from last month's packet, he had written a narrative argument, but I'm not seeing it in this month's package. Do you have us to see that?
Mr. Chairman, Member Winters, if it'll please the chair and the member, I'll walk the board through the argument.
Okay, perfect.
In my opinion, it's pretty straightforward. It shouldn't take a lot of time. Mr. Chair, we're opposing. Could we get a copy of what's already?
feel like Judge Judy here tonight. Please proceed.
Be on our best behavior.
Just not getting paid as much.
Yeah. A little short of that. Please proceed.
Thank you, Mr. Chairman. Why are we here? We're talking about property located at 46 North State Street. To get the board's bearings, that's on the corner of Montgomery Street and North State Street. Currently, the Rally Agency is there. It's an accounting office, and then there are 3 tenants that are engaged in professional work. Before ECR PDK purchased the property in 2016, it was a law firm also with tenants that engaged in, I think at one point in time there were residences, but then later it all became professional. So that's the property. The first page of what I've handed out is a boundary worksheet that was prepared by Richard Bartlett relative to litigation in 2014. What had happened is an employee of the law firm had fallen in the parking lot, and it wasn't clear as to whose property, on whose property, I should say, the employee fell. This was generated to determine that, and appropriately X marks the spot. But what this plan also demonstrates and shows is the location of an easement. You're going to hear a lot about title tonight, but I just want to get the board's bearings on what we're talking about here. So there is a driveway that exists between 46 North Main Street and 24 Montgomery Street. And if the board turns the pages, there's an aerial shot that I obtained from the city's GIS website. There's 46 North State Street on your left, 24 Montgomery on the right. You can see the driveway. There's a car parked. I want to draw the board's attention to the 2 cars that are parked up close to the northerly property line. We'll talk about that in a little bit. On the next page, this is the 3rd page of the handout. This is an image capture from Google from August 2018, and it shows the subject property from Montgomery Street. You can see a car parked toward the right side of the driveway on Montgomery. You'll see cars parked in the back by the fence line. And then you turn to the next page. This is a screen capture from Bing Maps dated 2013, generally showing the same area. And then the 3 photographs that follow are looking at 24 Montgomery Street and the driveway from 46 North Main Street. So imagine if your back is against the building on 46 North Main Street on its easterly side looking east. And the last page is the 2nd page of the code enforcement officer's decision that brings us here tonight, showing a car parked, and that car is parked on the west side of 24 Montgomery Street. And you'll hear from those abutters later. But generally that's to get the board's bearings on what we're talking about, and it is those pictures on the last page, and I'm sorry, those are the best pictures that I have. There may be others, but those are the best ones that I've been able to obtain. And so that car belongs to the owner of ECR PDK, and he's parking his car there. Why is he parking his car there? Well, he has 7 employees, and he needs to park himself, and there aren't enough spots. Sometimes he's forced to pay for on-street parking, feed that meter, because he also has to maintain spots, 3 spots for the tenants. There aren't enough spaces. Historically, I told you that there was a law firm there, and now there's similar professional offices. And under the ordinance, if it's general business, under Article 2872ED, you need 1 space per 250 square feet of gross floor area. And if it is other financial professional business under Article 287-2EF, you need 1 per 300 square feet. So this building either needs 27.62 spaces or 23 spaces, and it has 7. So what did the owner do? He went to add a space, and this is where it gets a little counterintuitive, and I'll go slowly. The ordinance requires either 27 or 23 spaces, depending on how you want to label it. and it doesn't have that. This property is non-conforming with respect to the number of spaces. In order to make this property more conforming or less non-conforming, you need to add parking spaces to it. So by adding a space, we make this property less non-conforming. You'll hear testimony from Attorney Goldman that historically and today, cars parked within 5 feet of the property line. That is the ordinance that the code enforcement officer said this property owner is violating. So in historical perspective, parking within 5 feet is a grandfathered attribute of the use of this property. By adding a space, the property owner attempts to make the property less non-conforming, maintaining the historical ability to park within 5 feet of the property line. Question, why we're here. Can the property owner do that permissibly under the ordinance? And I propose to you, the answer is yes, by the plain terms of your ordinance. How do we get there? This is how. The purpose of Article 28-81 is to reduce nonconformities. Adding a parking space, in this case, reduces the nonconformity, the requirement that you have either 23 or 27. As I mentioned before, there's only space for 7 parking spots. To reduce the nonconformity, the owner must add a space. Under Article 28-8-4A5, a property owner may reduce the nonconformity by right if there is no net increase in the number of off-street parking spaces required. As I told the board before, the use before 2016 is the same as it is today. So by right, you get to reduce the number of parking spaces, and under 28-845B, you also have to make sure that you reduce to the greatest extent possible the requirements of 28-7. So by adding a space, we reduce to the greatest extent possible, we add 1 space, thereby making the property less non-conforming, and that is something a property owner, or I should say the owner of a non-conforming property in the CVP district with this historical fact pattern gets to do by right. And in that respect, the code enforcement officer's decision to impose the 5-foot setback requirement, and I believe that's 28-77G2, 28-77G2, was unreasonable and unlawful. And this board has the discretion under RSA 674-33 to reverse that decision and permit this property owner to have this extra space, which will make the property less non-conforming. Now, that ends the presentation on that. I'll bring Attorney Goldman up here in a minute because, Mr. Chairman?
Can I ask a question before we
Yes.
bring Attorney Goldman up?
Sure.
So when was the restrictive provision of the zoning ordinance adopted? When was this 5-foot setback adopted?
That is a good question, and my understanding is that it was in the 80s or the 90s,
And when did this parking in this location begin?
forever. This building is going back to 1800, and in the 1970s, this lot, 48 North Main Street and 24 Montgomery Street and other properties were the subject of a Concord's urban renewal project. Winter Street was discontinued. Winter Street was where the Sycamore is now. But it's not clear from the ordinances where this 5-foot provision arose. But nevertheless, we know that on this parcel, people were parking within 5 feet. And Attorney Goldman may be able to testify as to what he saw before he bought the property. But that's, as we understand it, the historical nature of the property. It's been ongoing. And if it hadn't been, we would have expected the code enforcement officer to say, no parking on this property may exist within 5 feet of the property line. And that's not this case. So that is an important distinction to make. The other thing I want to briefly talk about is on the first page of the handout I gave you, that plan, the board's going to see the driveway. And there's a dotted line, not to be confused with the property line, that shows the extent of the pavement on the properties, both 24 and 46, and the board will note on the north side of the property and on the east side of the property, the pavement on 46 goes almost to the, well, on the north and the east, it goes to the extent of the property line, except for this small landscaped area that sits along 24 Montgomery Street, which is where the owner of 46 has parked his car. That area now has been changed. That, as you can see from the pictures, the large tree died, it was removed, and the owner of 46 put in some gravel to park his car, and that car, importantly, does not block the driveway. You're going to hear some talk about easements arising in 1970 granted by the Concord Housing Authority saying, hey, we have an easement right. It's true. The easement starts on the easterly side of the building at 46, but it doesn't say where it ends. But importantly, it doesn't say it extends all the way to the westerly side of the building on 24 Montgomery. And if you look at the pictures, you'll see why, because there's been that earthen landscaped area, whatever you want to call it. And with that, I'll call Attorney Goldman up to testify.
Before you do that,
Yes, sir.
take me again through what you're saying. I understand the part about reducing the nonconformance. But you're saying that you have the right to reduce the nonconformance in violation of the ordinance, which is to say closer than 5 feet to the property line, because you've always done it that way.
Because the property historically has always had parking within 5 feet of the property line. And from our position is that practice existed prior to the requirement that you have a 5-foot buffer. I think that requirement arose in the 90s, I'm pretty sure.
Why wouldn't you ask for a variance?
Because under the ordinance, the property owner is permitted to do it by right under 28, I apologize, I don't want to misspeak on the code provision. Under 28.84A5, A and B, the property owner is permitted to add the space by right without requesting the variance in the first instance.
Do we have a copy of that?
But only if it was legally non-conforming in the first instance, right?
That's right.
Okay.
Excuse me, what was the reference, 28?
28.84, and then you scroll down to
I'm going to flunk the eye test here.
Yep, no, I'll enlarge it for you, hold on.
I have my reading glasses, I got my distance glasses.
Maybe I won't.
Yeah, it's, because it was there beforehand.
28.4,
5.
sorry?
Keep going.
Keep going down.
8.5, she said.
There we are.
28.845.
Yep.
Okay, let's stop a minute and let an old man read the text here. That deals with the non-conforming, reduction in non-conformance. Where does the right arise because you've always done it that way?
Because parking within 5 feet is a nonconformity that has always existed, and by maintaining it, we're not increasing a nonconformity. So if we were parking within, well, in this case, they're parking right up to the property line, but I'll give the chair an example. Let's say historically the property owner was parking within 3 feet of the property line instead of the 5 that's now required. If the property owner, under these facts, proposed to add this space here, but park within 2 feet, we can't use this. But because, as Attorney Goldman will testify, historically parking on this property has been up to within 6 inches of the property line. And that's where, if you look at the code enforcement officer's decision, that's basically where this car is parked, within 6 inches of the property line. So that is why maintaining the historical distance from the property line is not an issue in this case. The question is, can we reduce the nonconformity of the number of spaces under 5? And we can. We can add 1 space. That's all this case is about, 1 spot.
So Chris, I had a question. Are you done? I had a question.
Yeah, go ahead.
So I think I'm following what you're saying. So the property owners added an additional spot number 7 or 8, right?
8.
And so it's not this spot that has always been within 5 feet of the property line. There are other parking spots in the property that are within 5 feet of the property line.
That's exactly right.
So having
this-
some, oops, sorry.
So this is a new spot within 5 feet of the property line.
That's correct.
Okay.
And when was this new spot added?
I believe it was added sometime in April or May, right after the code enforcement officer's letter came out of this year. And that's,
So-
well,
You mean right after the letter came out?
no, before.
Right before it came out?
The letter was,
Prompted by-
it's my understanding, the letter was a response to the neighbor's complaint,
Got it.
Why did you only add one spot?
because that's all he needed.
So in theory, you could line the outside of the building with parking spots, and they would be within 5 feet of the property line?
You could, but that's not why he's here. He's
I
adding.
understand that, I'm just trying to understand.
It would be, I would tell you from this property, and specifically if you look at the front page and the handout and the other pictures, you're not going to be able to put another parking spot within 5 feet of the property line. It's full. Part of the reason is 48 North State Street also has the right to use that driveway. That's one of the reasons why historically the cars have parked so within 6 inches of that northerly property line to allow the other two properties, 48 North Main Street and 24 Montgomery Street, to have access to their properties. So this is really the only space available left on 46 North State Street to put another spot that is within 5 feet of the property line. Yes.
How many total spots did you say there are?
8.
Okay, 8. And so
8
there-
for 46 North State Street, but there are, I believe, well, now there are 8. He wants, I'll make sure the math is right, 8. He wants 11. Because right now there are 10. 7 for 46 North State Street, but there are 3 on 46 North State Street that are dedicated to tenants.
Oh, right,
So
okay.
ECR, PDK, and the rally agency can't use those spots. The tenants have those. So there's-
Are all 10 of those non-conforming?
yeah,
They're all, yeah.
that's correct.
So, pardon my obtuseness. So are you saying then that because the other parking spaces have historically been in violation of the ordinance, it's therefore okay to put a new parking space in violation of the ordinance in another part of the lot?
I will say, I agree with the conclusion, but I don't agree with the way it's articulated, and I don't mean that in a bad way.
You can mean it any way you like.
Well,
I'm just trying to understand this.
If one characterizes the parking that's occurred on this property as in violation of a zoning ordinance, that's legally incorrect. The parking has existed as a nonconformity.
All right,
Illegal-
let's call it nonconformity.
Right, and so, because illegal has,
Yes, I understand, yeah.
so
Okay.
historically, the nonconforming aspects of the parking on this property, yeah, they've been there. And by adding this one spot, right, because we replaced the law firm with an accounting firm and other professional offices, that's permitted in the CVP district, permitted use in the respective district, and there's no net increase in the number of spots. So, in fact, if it goes from general business to general business, it's 250 spots, or one space per 250 square feet gross floor area. If you call it professional finance, then it actually reduces and it becomes one space per 300 square feet. So we don't run afoul of 5A, and we comply to the greatest extent possible with 5B by adding a space and reducing the number of spaces that the property is otherwise non-conforming with.
So does this imply that, for example, you have a building that is built in the setback, let's say, and it's always been that way, ever since the zoning ordinance was passed, that the owner could then add another building so long as the building is allowed by right in the district within the setback, or more building within the setback, without requiring a variance?
I'll be honest with you, will you say that again? Because I don't want to misspeak in my answer.
What I'm trying to do is draw an analogy to things we see all the time here. Perhaps analogy is the wrong word. If we argue that because other parking spaces on the property are non-conforming and have not been non-conforming, are grandfathered, let's say, that we can introduce a new one that is also non-conforming in the same way without securing a variance. That's what you're arguing, correct?
That's what I read this ordinance to permit, sir.
Okay. So let's say we have an existing condition of some other sort besides parking spaces on a property. For example, a building on the property is in violation of the setbacks. It's non-conforming. Can I then add to that building non-conforming in the same way in the setbacks because the existing one is already there?
I understand your question.
Is that a false equivalence to what you're saying?
Yes, and the reason is because the ordinance treats parking differently than it treats other types of nonconformities. So under your example, you would, by building a new building, you'd be increasing the nonconformity because let's say you have one building on the property line. This only speaks to parking spaces. This ordinance doesn't say you get to add another building. So under your hypothetical, if I'm going to build a new building, that new building is not replacing an existing use with another permitted use, because see how this is saying you're replacing. I think when I read this, I'm thinking whoever drafted this knows what's happening in downtown. There's limited space. Under your suggestion, we're adding a brand new building, which would involve a host of other problems. And the new building would probably, unlike this provision, would trigger site plan review, but this doesn't because it's just one permitted use being replaced by an identical use, which isn't a change of use.
Yeah.
Everyone else got to talk, so I want to try.
That's a good reason.
Yeah. The one thing that's different with your analogy, and Fritz, please correct me if I'm wrong, is there's always been the parking within the 5 feet. They're trying to add a parking space to address one of the nonconformities. There's kind of two. One is where they're parking, and the other one's the number of spaces. By adding the parking, they're reducing one of the nonconformities, and to their argument, keeping the other one the same. That's what they're trying to do. At least I'm understanding it.
So the crux of your argument is that there has always been a parking space there?
No, sir. The parking space
Within the
that brings us here tonight is new. I make no mistake. That is new as.
I meant within the 5 feet of the building.
So are we not reducing one nonconformity but increasing another?
No, because on this, the answer to your question is yes, if there had never been parking on this particular lot within 5 feet of the boundary.
Okay. Proceed,
Attorney Goldman?
unless anyone else has questions.
Oh.
Where is it appropriate to sit?
Why don't you have a seat right over here to my right,
Oh, right here.
Mr. Meckel's left. Can I swear you in?
Of course,
Swear to tell the whole truth and nothing but.
I do.
Would you identify yourself for the record, please?
Stephen Goldman.
What would you like us to know, Mr. Goldman?
You want me to testify, or are you going to ask me questions?
I'll ask you questions, and then the board may have questions of you. So
Okay.
if that'll please the chair, we'll do it that way.
It's all right, as long as the board is happy with it?
Okay.
Okay.
Mr. Goldman, do you recall when you owned the property we've talked about as 46 North State Street?
Yes, I purchased it sometime in 1983, sold it in 2016.
Look, in front of you is an exhibit that I handed the board this evening. On the first page is a plan. Have you ever seen that plan before?
I have,
Do you know what that plan is?
yes.
What is it?
It was a plan designed to delineate the exact boundary line between the 46 North State Street property and the 24 Montgomery Street property. So at the time, it was my office, and John McIntosh owned 24 Montgomery. So that was designed to tell us where the boundary line between the two properties were.
I represented to the board earlier tonight that this plan shows the extent of pavement on your property in 24 Montgomery Street. Are you able to discern on this plan where the pavement is?
Well, of course, it's all white, so, but I think that you can assume that the pavement, in fact, is the entire driveway and the entire parking area on the north side of the properties.
Does the pavement on 46 North State Street go all the way to the northerly boundary of the property?
I'm not sure if it goes all the way to the boundary, but virtually all the way.
What's on the northerly boundary of the property?
Again, I don't know exactly where the boundary is, but where I assume it to be, there is a fence.
Historically, did you park cars there, or did people that use that building park cars there?
Yes,
And how close to that northerly fence line did those cars park?
as close as you could reasonably do.
6 inches?
6 inches would be a fair estimate.
Okay, and you said, what year did you buy this property?
83.
83. And when you bought the property, were you aware of the parking situation at 46 North State Street?
You know, it's a long time ago. I'm sure when I bought the property, I educated myself as to what the parking situation was. I owned 48 North State Street too, which I believe I acquired shortly after that. I did so, frankly, so I could use the extra parking. So I would have done my due diligence to determine how the driveway worked, but I don't recall any specifics at this point.
Okay, I want to turn your attention to the driveway. This plan shows, and if you turn the page, you'll see pictures showing the property. There seems to be an earthen landscaped area between the property and the building that is 24 Montgomery Street.
Correct.
Okay. Turning back to the first page, do you consider that to be property of 46 North Main Street, the property you owned, or do you consider that to be the property of 24 Montgomery Street?
You're misspeaking because you've been saying Main, but I know you mean State Street, of course.
Thank you, sir.
Yeah, so, I mean, when we had this plan developed, obviously, it's apparent from the line that at least a portion, the majority of that landscaped area was part of the 46 North State Street. But honestly, I had no idea until this plan was done where the property line was, and it didn't matter to me, so I never had occasion to need it until a legal issue arose.
Okay. And did anybody, from the time that you owned the property, did anybody ever use that earthen area next to 24 Montgomery Street for access?
I mean, it was landscaped. You couldn't, a vehicle could not pass through it. There was a tree there and other shrubberies.
All right, so that's, in your mind, that was never part of the access to the other two well, it was never access to 46 North State Street or 48 North State Street or 24 Montgomery?
To my knowledge, I've never seen a vehicle in that area until recently, because I'm working across the street, so I do see what happened to the area, but before that, no.
Did you ever see an owner of 24 Montgomery Street take any acts in order to make a claim that that earthen area adjacent to 24 Montgomery Street belonged to 24 Montgomery Street as opposed to 46 North State Street?
I don't know what you mean by acts. John McIntosh maintained the landscape area. I had no interest in doing so. It was almost touching his building, and it meant nothing to me. I was happy when he landscaped it. It made the area look nicer. Other than that, I don't recall any activity occurring.
So in 2014, you learned from this, in your testimony, you learned from this plan that that earthen area was in fact your property, correct?
That's true.
And in 2014, you said there was litigation involving also Mr. McIntosh or his law firm, correct?
Right. I think it was him because he owns the property. But yes, some way or other, he was part of the, he was a defendant and I was a defendant.
And did he, from 2014 going to, until you sold the property in 2016, did Mr. McIntosh ever carry himself out or promote the fact that that earthen barrier was his property or property of the owner?
Mr. Mecca, how does this bear?
It's going to come up, unfortunately.
Could it come up pretty quick?
Yeah, I think we've made our point.
Okay.
Thank you. I don't have anything further for the board except for rebuttal if it comes up.
Okay. But could you explain to me why it matters whether or not the garden is on one piece of property or the
I'll
other?
represent to the board that you're likely to hear testimony and argument that the owner of 24 Montgomery Street acquired that earthen area via adverse possession.
And how would that matter?
It wouldn't matter for this board, but I have been in this situation before where an owner of an adjacent parcel claims that he, she owns the property, and therefore the board can't grant the relief requested because it's on someone else's property. So,
But you're not parking on the garden, you're parking across the driveway from it.
no, that's, if you look at the code
Or
enforcement.
did you remove the garden and put in the gravel? Is that something I missed here?
The gravel exists, if you look at the second to last picture in that packet, it's the one with a stump with a brick on it.
The parking spot is essentially here.
Closer to the northwest corner, down a little bit.
Where's the parking spot?
Here, I'll show. The code enforcement officer's picture, I believe, is taken on Montgomery Street facing north and shows a car here. That's where it is.
So the car is where landscaping used to be?
Right, just north of the tree that was removed sometime between 2013 and 2018.
That's why there's the stump with the brick on it, right?
Right.
In the pictures.
I see. So the stump with the brick is where you're parking the car.
And that's why we were talking about.
That's why it matters who owns the land.
That's right.
Okay. Okay, very good, thank you.
Thank you, sir. Thank you, sir.
Is there anyone who wishes to be heard in favor of this appeal? Is there anyone who wishes to be heard in opposition to it? Please come forward.
Mr. Chairman, my name is John McIntosh. Yes, I swear that when I testify here will be the whole truth, nothing but the truth, so help you God.
Thank you.
Mr. Chairman, my name is Mark Dunn. I'm a tenant in his building, and I did all the title work and provided with the maps and everything that you have and wrote the cover letter to you. So I don't know whether you want me here at the same time.
If it makes things more efficient, sure.
I think it would.
Okay, please join us.
Well, Mr.
Let me get sworn in.
Oh, yep. Swear to tell the truth.
I swear.
Thank you very
Okay.
much.
My name is Mark Dunn. I'm an attorney here in town. In his office, I'm a tenant since 1995 at 24 Montgomery Street. And my specialty is real estate titling and conveyancing. So the materials that I sent with the cover letter to you I generated.
Very good. Gentlemen, who among you would like to speak first?
I will speak first. I want to reserve a little bit of time for Mr. Dunn to address what I think is an important development in this case, which is the master deed to the 3 properties affected by this area of parking, 4624 and the additional building that's next to 46. All benefit from a deed that was given by the Concord Housing Authority a couple decades ago. The area that we're talking about, this is a driveway, not a parking lot. The area that we're talking about, by deed, says that the beneficiaries, the 3 property owners, can use it for egress and ingress solely. A driveway, not a parking area. So with that primer, I want to address a couple things that Mr. Meckel has said. And with all due respect to my good friend Steve Goldman, who I've known for over 20 years, and we lived harmoniously throughout that time, the area where Fritz is suggesting it's non-conforming in the back, which is the north side of the property with a stockade fence, in fact has a buffer zone of anywhere from 2 to 3, in some cases 4 feet, with plants and growth. It's not right up within 6 inches of the building. It's within a couple feet of the building. Whether it's 3 feet of the building, I'm not sure, but certainly it is not right up against the stockade fence. And to my knowledge, neither Steve nor I have ever had any complaints from the owners of that property, largely because it's a backyard, there's a pool, and there are a couple of different apartments, and the stockade fence is there to create a barrier. What we're really
The
talking...
buffer's on your side of the property line or their side?
It's on our side.
Okay,
I mean, assuming that the stockade is the property line,
all right.
then the buffer is on our side. Okay, so it's not within 6 inches, it may be within a few feet. The area that we're talking about here is a driveway. Historically, that has been maintained by 24 Montgomery Street. You see that in the photographs that have been offered by Mr. Meckel. It has always been that case since I moved in almost 30 years ago, 1992. In fact, the stump that you see is a tree that I removed, in large part because it was encroaching not only on the driveway, but also it was going to fall down on Steve's roof at some point. So that was removed. The logs were taken back to my property. They were chopped up and removed from the property. It has always been maintained by 24 Montgomery Street. The driveway itself is already non-conforming. Under current standards, it would have to be 24 feet wide because it's both an egress and an ingress. It's not. It's about 16 feet wide. And that's with the landscaped area. Even if you, and let me just say that what you see as being a little bit, no one has ever parked in that spot, which is right adjacent to Montgomery Street, in the 30 years that I've been there. Certainly Attorney Goldman didn't do it. None of our clients have done it. This was a self-help effort, frankly, that was done by Mr. Rowley over the weekend, where he removed all the landscaping and replaced it with gravel. It was at that point that he decided that was going to be his new parking spot. So the problem that I see, not only aesthetically, but in terms of, well, I guess aesthetically in part because it was maintained and it has been landscaped over the years, is that it's a hazard. It's substandard already. If you park a car there, and the car that Mr. Rowley has been parking there is approximately 6 feet 1 inch, and then add to that the other car that he's parking next to his property, which
6 feet 1 inch wide, or?
It's 6 feet wide,
Right.
6 feet wide. That whole landscaped area is only 7 feet wide approximately. So even now, when he did park there, it was often on the asphalt, not just simply on the gravel. And that was when he put his car within a foot or 2 feet of 24 Montgomery Street. I simply don't believe you'd be able to get a plow in there with a 7-foot blade, understanding that the plow's going to be issuing snow to either side, let alone a fire truck or an ambulance in some circumstances. So I think allowing that new spot, which has never been used as a parking spot, as a parking spot would be a hazard. That's all I really have to add. I'd like to ask Mr. Dunn to address, I guess, the more difficult issue of how does a driveway become a parking spot when the deed providing for it limits it to a driveway? And that's the city's deed from the Housing Authority. We all have to live with that. And so I would ask that the board consider enforcing the 5-foot setback for any number of reasons, which I've mentioned here, and appreciate the time.
Thanks. Mr. Dunn?
Yes. You have in your in the materials I submitted to you the title chains for 46, 48, and North State Street and 24 Montgomery Street. And historically, before Winter Street was closed off, just to orient everybody here, this is where Winter Street used to be, right there. It was in this area, and the southerly boundary was the property bordered the northerly property line for 48 and for 24 over here. And that historically, there were driveways going that way out, and then 46 had its driveway going this way. When the urban renewal project was done in 1970, and the Concord Housing Authority took over and bought this house right here, and the city was thinking. They bought this thing, and they then granted to this house and this house driveway easements over this property because they needed to provide access for these two properties that had lost their driveways going out onto Winter Street. And in the deeds that are given, and in fact, I will read to you from the deed of the Concord Housing Authority to Thomas and Beulah Musgrave, which was the first conveyance out of the city, out of the Housing Authority, burdening 24. And in it, it says that at the bottom of the first page, a rights-of-way being granted to Lamson and to Robinson, and just for reference purposes, Mrs. Robinson, I'm sorry to make references, graduate, Mrs. Robinson lived here, and the Lamsons were here. Okay, so the references to Robinson and Lamson are absolutely correct, because my materials will show that the Robinsons had this property and the Lamsons had this property here. And reading from the deed, the above described conveys subject to the right of Robert Lamson, Robert and Lillian, their heirs and assigns, and the right of Margaret Robinson, her heirs and assigns, to cross and recross the above described property by vehicle from Montgomery Street to the properties of said Lamson and Robinson. Said rights of way being granted for the purpose of providing access for said Lamsons and Robinson to Montgomery Street, and to be used solely, S-O-L-E-L-Y, as a right-of-way across the portion of the premises, above described premises, as lies easterly of the dwelling house thereon. And I would suggest that either north is this way, east is that way, south is that way, west is that way. That you either are going to say the easterly side of the dwelling house is either this, or alternatively this, okay? And every deed going forward in these title chains all say solely for a driveway, and they always say the easterly side, at least in the title chain for 48, says the eastern side of the dwelling house. So, what is the width of the driveway? I would respectfully submit that it is the east side of either this line here, or alternatively that line there, either one, going all the way to the property line. And as Mr. McIntosh has said, that even during summertime, with one car parked right in this area right here, by first Mr. Goldman and now by Mr. Rowley, this driveway is narrow, and I can testify myself. I have pulled into this thing where there are people either for this house or for 46 coming out, and either that person backs up and I go in, or alternatively I back out and let the person go. In the wintertime, with the snowbanks here, the parking goes out this way. And we all have to swing this way, and if there's no car parked here, we can swing that way, so that we can make the turn without hitting these people here, the cars that are parked here. With the car parked there and a car parked here in wintertime, we have to basically turn, and we use, I know I've done it, I've used the end of the snowbank to spin my front of my car fast enough so that I don't clip this car over here. And in 30, 25 years, however, I can't add up from 95, I've never done so, mercifully. So that the city created this thing, and the restriction against the house is simply, unwittingly, a reconfirmation of what is already a poor situation. And I guess I would reiterate that I think we're simply changing one nonconformity for another nonconformity. To the extent that people were parked back here against the split rail fence, in fact, you're out not 6 inches, it's more like a foot or 2 feet from the nose, the bow of the car, the front of the cars. And, you know, over here there hasn't been complaints. Here, I think this was always a garden in here, or landscape. Mr. McIntosh maintained it. Mr. McIntosh had the tree taken out of here. We always maintained this area, and I think it's best that it be left that way. I think it's also a danger for fire equipment to get in if you constrict this even further. If the car is parked not on the thing, but out 2 feet or so, and you add another 6 feet to the width of the car, you have really pared down the width of this driveway, which is meant to be two-way. It's hard to be two-way given the fact of how narrow this is in here. So what was created in 1970 was the best of a bad situation. And I think having another car in here simply makes it worse. And I guess, in conclusion, I would have suggested that part of the due diligence of Mr. Rowley was to figure out how many parking spots can be done in here. And I'm not sure that analysis was engaged in. I will also say, as a matter of fact, that when you see the title change for Mrs. Robinson, Mr. Goldman reserved 2 parking spots in here specifically for this house. And he did not reserve for the balance of it, because he owned this property and this property. So when he had both pieces, he had the freedom of however many, and to the extent that he rented this to a woman named Deborah Roy, he allowed her to have a spot in here. But when he sold it, he put into his deed 2 spots parallel to this line, one here and one here. So the remaining spots then for Mr. Rowley was whatever was left in this area here and over in here, but not in the driveway. Any questions?
Any questions from the board? Questions? I think we're all set. Thank you.
Thank you very much.
Thank you.
Is there anyone else who would like to be heard in opposition to this appeal? Any comments from code enforcement?
I think I would like to just share another part of the ordinance that we utilize in determining how we came to our, not a notice of violation, it was not a notice of violation that was given, it was just an informative letter saying what is happening here, and this is how we got there. If you look at 28.4A1. That's all I have.
Any questions from the board? Very good. Mr. Mecca, would you like to offer factual clarification in response to anything you've heard?
Yeah, very quickly. Attorney Dunn said, to the extent, I don't think this board has jurisdiction to resolve title disputes and who owns what land, but to the extent that it matters for the board, take this into account. Attorney Dunn says, this, what we're calling the buffer area, he says, that land was always the garden. Always the garden. Look at the handout I gave you. Look at the size of the tree that was there. Does that look like the kind of area that the whole world considered was the driveway? Because remember, you heard the title. I generally agree with most of his title, except for the critical part. The driveway size, the width, is not expressed. It's just it's a driveway. What's the driveway? I'm going to get Attorney Goldman up here to tell you what the driveway looked like back in 1983.
No.
Okay.
No.
So to the extent the board needs to make that factual determination, common sense shows, the pictures show, no one was using that as a driveway. It's not a driveway. That's property of 46 North State Street. The other thing I'd point out to the board is Attorney McIntosh says that Mr. Rowley is parking his car within 1 to 2 feet of his building, 1 to 2 feet of 24 Main Street. And you also hear that, to contradict Attorney Goldman's testimony, that the cars in the back of the property, the north side, are parking within 1 to 2 feet. Take 1 to 2 feet. Mr. Rowley's doing the same thing. If you accept Attorney Dunn's testimony and you accept Attorney McIntosh's testimony is true, then Mr. Rowley parking within 1 to 2 feet of 24 North Montgomery Street is the same as what's been going on there for years. If the cars in the back park 1 to 2 feet, that matches what Mr. Rowley is doing now.
Any questions? Thank you very much. With that, we'll declare the public testimony of the hearing, portion of the hearing closed. We have a request that the board overturn the code administrator's decision that the subject property must comply, and that the rule that the property may have a nonconforming parking spot in the setback area on its southerly side, that is to say, up against the neighboring house. We heard testimony that because there are existing parking spaces that are elsewhere on the property that are already nonconforming in that manner, that the appellant believes he has the right, without a variance, to introduce another one in this location. Starting with Ms. Spector-Morgan, what are your thoughts on this?
I think the easement and the deed issues are interesting, but not our issues. I think the safety issues are legitimate, but really go more towards any variance request that might come as opposed to an administrative appeal. I think, we all agree they can decrease the nonconformity of the number of spaces by adding a space, but that new space has to be legal. And they're claiming that this new space they're adding is an existing non-conforming use because elsewhere on the property there is parking within that setback. That's not how the law of non-conforming use works in my understanding, nor is it how I read the city zoning ordinance. I think just because there's a nonconformity on a different part of the lot doesn't mean that you can expand that nonconformity to a new parking spot on a new part of a lot. I think this spot itself would have to be non-conforming to be protected, and admittedly it's not, so I would vote to uphold the decision of the code enforcement officer.
Mr. Witters?
I agree.
Ms.
Hard to
Scott?
follow that. I agree. She said it much more eloquently.
Kim?
Yeah, actually, a question for, I don't need the answer to come to, but when you're challenging the code enforcement's interpretation, who has the burden? Is that the applicant?
The applicant has the burden.
Yeah, okay, all right. Well, I don't think that burden has been met, so I would agree with Laura's take on it. So.
I also agree with my colleagues. Would anyone care to make a motion?
I move that we deny the appeal and uphold the decision of the code enforcement officer.
Using the rationale of the remarks that you made earlier.
Yes.
Is there a second?
Second?
Is there any discussion? All in favor?
Aye.
Anyone opposed? The vote is unanimous. The code enforcement administrator is upheld.
I think it would probably be helpful, though, that your motion did include, or it said
My
nothing to...
explanation.
Had nothing to do with the property rights associated
No,
with it, right?
no, nothing to do with property rights.
Very good. That moves us to case 4421, Greater Tilton Area Family Resource Center. The applicant requests a special exception from Article 2824J, Table of Principal Uses, to operate a social service center, educational and institutional use B6, for property located at 202 North State Street at a UT Urban Transitional District. Hi. You swear to tell the truth and nothing but the truth?
I do.
May we have your name, please?
Michelle Lennon, Executive Director for the Greater Tilton Area Family Resource Center.
Could you spell your last name, please?
Lennon.
What would you like us to know, Ms. Lennon?
So I contacted Mr. Walker in the zoning board office because we wanted to rent the 202 North State Street location for a new family resource center. And he was really wonderful, so he helped the social worker kind of fill all this stuff out. So I'm hoping that you have all the information you would need.
We do have your application, and we have read it.
For the special exception. And from what I understand it, because it was an urban transitional district, we just needed to file that application.
Yeah. In order for us to grant a special exception, we have to find that you meet the conditions of a special exception, which you did make some notes about in the application, or one of your colleagues did. Would you want to touch briefly on why you believe you meet those conditions?
I just looked at the zoning thing and said, okay, we fit into this, so.
Fair enough, but a couple specifics would help us understand why you think so.
Yeah, well, we're a comprehensive family support organization, so like the Friends organization was there before, we were a similar social service, and it appeared that those services qualified. So our main programs are comprehensive family support, which includes parent education, and then peer recovery support services and training.
Do you have a lot of people coming and going, or is it a?
It's pretty limited because, I mean, COVID kind of changed how we operate, pretty much by appointment only, and most of us work outside the office.
I see. So it's primarily administrative office?
Well, that, and it depends, because we get walk-ins too, and we have 3 drop-in offices to meet with families, like if somebody needs assistance with applying for like New Hampshire Easy Benefits, or I'm trying to think of what walk-ins usually come in. Sometimes it's reading paperwork, connecting them to like the VITA service for tax preparation. We tend to remove barriers for families looking to be self-sufficient in some way. So sometimes it's helping somebody locate a birth certificate, or getting a copy of an ID to get a job, or filling out, New Hampshire Easy is a common one where we're filling out applications for assistance for different things.
So it would be 1, 2, 3 people at a time?
We have
for
a
that kind of meeting?
center manager, 2 family support specialists.
I'm at the visitors.
Oh, for visitors? Usually it's either one person, 2 people, or a family.
Okay.
At a time. And then sometimes, the individuals that are offering the support will make appointments with their people to come back in, if they're coming on site for assistance, sometimes use the internet or look for jobs or things like that.
Very good. Other questions from the board?
I don't have a question. I actually used to work at the Friends program,
Oh.
and I know your organization. It's the same situation. The Friends program offered the same types of services. We had the same level of activity with trainings and family supports, and their operation would fit there. It would be seamless to do it. So.
Andrew, any questions?
No.
I have none.
No, but I think in fairness to the process, there's a couple of requisite findings that perhaps haven't been noted, so maybe I could just point them out. Do you see this as creating undue traffic congestion or impairing any kind of pedestrian safety?
No, there's plenty of
Do
parking.
you
in the
see
lot.
any, do you see this as overloading any public or private water drainage or sewer systems? And finally, do you see this as creating excessive demands for municipal police, fire protection, schools, or solid waste disposal services?
No.
Okay. Thought I'd do that.
Good job.
Well done.
Thank you.
Well done. Is there anything else you'd like us to know?
I don't think so.
Very good, thank you.
Yes.
Is there anyone here who would like to be heard in favor of this appeal? Is there anyone here who would like to be heard in opposition to it? Any comments from code enforcement?
No, sir.
With that, we'll close the public testimony portion of the hearing. We have a request for a special exception for the Greater Tilton Area Family Resource Center, which is a social service agency, fair characterization, who would like to occupy some rental space in an existing building on North State Street, this current location, I believe, of Cobb Hill Builders and several
Yes.
other small offices.
Move approval.
Is there a second?
I'll-
It's been moved-
I'll second it.
It's been moved and seconded. Is there any discussion? All those in favor?
Aye.
Anyone opposed? The vote is unanimous. The special exception is granted.
Thank you so much.
Congratulations.
You're
Thank you to Mr. Walker, too.
Mr. Walker is enjoying a well-deserved retirement.
Oh.
He's watching, I'm sure.
Yeah.
Yeah. Yeah. He's more likely to be watching the Red Sox if he really wants pain. Okay, case 4521, Louis G. Day. The applicant wishes to store a 30-foot recreational travel trailer on a vacant lot and requests variances to Article 2824, allowable principal and accessory uses in zoning districts, to allow the storage of recreational equipment on a lot where a principal residential use has not been established, where such use is not allowed as a principal use and is only allowed as an accessory to a principal residential use, and Article 25534, outdoor storage of recreational equipment, to allow the storage of recreational equipment within the required side yard setback, all for property located at 30 Blackwater Road in an RO open space residential district. Mr. Day, are you among us? Please come up.
Apologize for my appearance, I just left home, so.
You look just great to me. Swear to tell the truth and nothing but the truth.
I do.
Could you fill us in on why you feel the variances are appropriate in this case?
Honestly, I don't know. I really don't.
No? It's an honest answer.
I don't understand all the laws. I mean, I just bought a piece of land, first piece of land I've ever owned. You know, I figured it was mine, I could do what I want with it, but apparently not.
No, alas, that is not 100% the case. I did read in your application that your plan is to convert the recreational trailer into a permanent building. Is that correct?
No.
No, he's building a,
No, I just bought a piece of land. The trailers or the camper is something I bought last summer, which I
Yeah.
had in storage. I had an issue with buying the land last year, so when that went through this year in February, I took the camper out of storage to save myself the storage cost.
I see.
And where it was in a storage unit or storage area, I wasn't able to work on it. I bought it with the understanding that the roof repair was done already. So when I opened it up come spring, the entire roof was falling apart and everything else, so I put it on the land where I already have a temporary service. So I have electric, so I could work on it, tear the roof off, replace it or whatever.
I see.
But I can't do that in a
So I
storage.
misunderstood your application. You do plan to renovate the trailer,
Yeah,
but not to live in it on that
no, no,
property?
no, nope.
I see.
Can you just explain what you want to do? That might help us.
Basically just need a place to store it where I can actually work on it. I've been swamped with work, like I've been working 80, 90 hours a week, so I haven't even had that chance to. So, I just need a place to store it, where I actually have the chance of working on it.
So you need a place to work on the trailer?
Correct.
And you're not planning to live in the trailer?
No,
Okay.
Is there anything else on that property besides the trailer?
my BMW?
But there's no structures?
No.
Are you-
No, I'm actually waiting for the septic plan from Felix Septic. Once I have that, I can actually put the building permit in. I was already planned on having it built by now, but I didn't realize that when I bought the land, there was a change in current use tax, which cost me almost 10 grand, so that set me back a little bit, so.
So your plan is to build a house on the property
Yes.
and live in it?
Yeah.
I see.
and you're asking for just a temporary,
The temporary
Situation
the house
until the house
probably
is built.
won't be completed until next summer, but I'm hoping, once all the paperwork and stuff is done, as far as the building permit, I'll have the foundation in this year at least. Then hopefully start building during winter.
Question for David. If there were a house on this property, am I correct that he would be able to store the trailer?
No,
there?
sir.
He would not be able to
We
store
do
it?
not allow the storage of recreational vehicles in the residential area.
Okay. That answers that
Sorry,
question.
could you repeat that?
We do not allow the storage of recreational RVs in a residential area.
This is a trailer though, right?
how big is the,
It's a
Well, yeah,
30-foot
the
travel
same thing.
camper.
Vacation trailer, yeah, okay.
Let me clarify that, hold on.
Wait.
Yep.
Because,
Yeah, you
I mean, you come down Bog Road, there's like 3 new houses there that all have campers and RVs.
I've noticed that rule is kind of spottily enforced.
Hold on.
I wasn't aware that there was such a rule.
yeah.
I
as such.
see RVs parked in, all over residential.
Yeah.
I'm sorry. Let me-
can't live in it,
Let me read the
approximately.
ordinance to you for you, sir.
Sure, yeah, that'd be great.
It's in all residential districts, recreational equipment belonging to the resident owner or occupant of the premises may be stored outdoors on the premises except in the front yard or the required side yards as specified in our section 2841 table of dimensional regulations. No such recreational equipment shall be used for living, sleeping, or housekeeping purposes.
Ah,
That's where
okay.
it mixed up.
Yeah.
Sorry.
Okay, so you can park it in the
In the back of your
backyard.
property, but you cannot utilize it as a,
Right, you can't live in
Can't
it.
send your
So
Uncle
if
Max
there's
out there to live in it.
correct.
So if there's no home at all, then there's no backyard.
right, so once his house is built on it, you'll be able to store, there'll be a place for you to store it on your property.
Yeah, there's gonna be.
But there's no house there
probably
now.
A 36 to 42-foot section for the backyard.
Yep.
Other questions from the board?
Well, I guess this is a question for enforcement then. Can we, I vaguely remember something like this.
Yeah, we did one in the South End a couple weeks ago.
Can we grant these for a year, it's like a year or temporarily?
Well, that's a question definitely for code enforcement, and we're going to, I guess we might as well ask it while we're sitting here. Do you know, David, can we do that?
So I think what we have to be careful in this application is he's also asking to be encroaching the buffer. So the ordinance allows for the storage in the backyard or the required side yards as permitted by the table of dimensions, which has certain buffers involved. In regards, once he has a house there, it can be an accessory use to the house. So yes, you can, as long as he builds this house, he's gonna be able to store his equipment or this recreational equipment in the backyard, but you still have to maintain certain setbacks from his property lines.
If, I think the thrust of the question in my mind was, are we empowered to grant a limited time variance?
I've got the last case that you looked at was on 8 Hope Ave, and it was granted, the special condition was granted in March, and it was granted for a 12-month period.
Right.
Because the applicant stated that it was going to be done by winter time. So the board did allow it for a 12-month period from the date of building permit.
So we thought we had the right to do that at that time.
Yep.
Not only right, I think there was something specific in the ordinance that allows for it on a temporary basis. Construction, we compared it to a construction trailer, I think.
What was the date of that 8 Hope Ave decision?
March.
That was March 3rd, the zoning board granted it, and it says, it would be 12 months from the date of the demolition, because they were demolishing the single-family home that was there, and they were rebuilding the single-family home.
What's the case number?
The case number is 821.
March 3rd of this year?
Yep.
Not to counteract my whole
That
case,
was
but I
just-
mean, there was already a pre-existing house,
Right.
so you
So
guys
that's a little
by
bit
law
different,
do
yes,
allow them
correct.
temporary use of a
Well,
camper.
It's a little different, though. That's
Yeah,
a different.
we
was living in
weren't
it.
comparing the cases other than the procedural idea or the legal idea. Do we have the right to say, you can keep it, you can have a variance for X number of months, and then if you still need a variance past that, you're out of luck, you don't have a variance anymore.
That was, so that was under
That was also,
2892, that was under a different
it's under
section.
construction. That's under the construction section, because they were getting a building permit. So,
Right.
We're also going to live in it.
yeah.
Yeah.
And we allowed
Right,
for,
the
I
issue
remember
of
this one now,
temporary
yeah.
permits, there's, can issue temporary permits for temporary use of a manufactured home.
Right.
Okay.
plus we allowed for a setback variance too on this one. Variance number 1 was,
In lieu of a single family, which has been, okay, which has been rendered by an uninhabitable, so that
it's
unfortunately,
different.
yeah, so I don't, I'll hold off on mine.
Back to the question of the setback, why not move the RV so that you're within the setbacks?
Didn't know that was an issue. I thought it was just the fact that the camper was there without a home.
Apparently, it's not only there, but it's also a little too close to
Well,
the
I think
property line.
it's supposed to be in the side yard, but without a house there, you
Oh.
can't determine it.
Is that what it
where the
is?
side
Oh,
yard
I
is.
see, there's, right, by definition, there is no,
Yeah.
Because it does show a sketch here of
The
a
camper
trailer.
sits about 100 feet in on the right-hand side of the
Yeah.
property.
But it shows it within the 40-foot buffer on the
Right side, yeah.
right side. Any reason why you couldn't move it to the left?
That's where the septic system's gonna be going.
is there anything unique about your lot that, you know, is?
There's a 25-foot incline rock ledge from 150 feet back. So, I mean, like I said, barely 38 to 42 feet for a backyard from placement of the house.
So that would prohibit you from moving the trailer backward, back toward the back of the lot?
Depends on how far up I set my house. I mean, like I said, 38 to 42 feet for a backyard, so I mean, I definitely have room to store an 8-foot section.
Because if the board, and I'm not saying we're going to, were to grant you a temporary variance here,
Yep.
both the side yard setback and the use, and the keeping of the trailer or the RV on the land both those variances would expire at the same time at the end of that period of time, which means that if you build your house, you can now have the piece of, or the trailer on the property, but you still can't have it in the setback.
Okay. That's
You
fine.
follow me?
Yeah.
So you would have to have a place on your property where you could put it.
Yeah, well, like I said, there'll be at least a 36 or 38 to 42-foot section for the backyard behind the house, so I mean,
Okay.
I'll definitely
So
have
you
to
could
go-
move it to that place now?
Absolutely.
Okay. That answers my question.
Is the trailer visible to any of your neighbors?
If they drive by where I have just recently cut in the driveway,
So it's visible from the street?
yeah.
If someone, I mean, they probably have to drive slowly, but if someone,
Yeah, I
if someone's
mean,
walking
just
down the
like
street.
passing any other driveway, you can see everybody's entire yard, so I mean.
May I ask a question?
You bet.
How long do you think it will take, how much work needs to be done on this? Now, I understand your work schedule and weather and everything else, but is this like a 2-month job, a 6-month job,
Doing the job wouldn't take very long. It's more so the fact of having to order the vinyl canvas from one of the camping companies. With the way everything else has been as far as special order stuff, I mean, I order a metal roof, it's supposed to be here in 4 weeks, and it takes 3 months, so, I mean, I couldn't tell you. I mean, if I had all the materials, I could probably have it done on less than a week.
But when it's fixed, you're not going to take it off the property. You're still going to want to keep it there.
No, eventually, I still keep it there once the house is built.
and so my follow-up
don't
question
sell it
was,
before.
so there's maybe, if materials are in, it's a smallish time frame job, not a, total rebuild from the
Yeah,
ground
no, I
up.
could probably rebuild that camper 100 times over before I build my house.
Right, but the next question is, so say the camper gets totally rebuilt, it's all done, but you still don't have the house. It's just going, your plan is to just store it on the site, not to live in it,
right.
not to,
No, I'm actually staying at my mom's. I was renting an apartment in the Royal Gardens, paying $1,300 something a month for a cockroach infested apartment. I decided to throw all my shit out and go live with my mom until my house is built. And if
I can
that's-
see why you'd feel that way.
So if it's an issue, like I said, my uncle lives 3 houses down, and my cousin Tracy lives 4 houses down. So I mean, I could always stay with them if anything ever happened at my mom's.
okay. Thank you, I just wanted to understand the long-term plans for the trailer. Thank you, sir.
No problem.
Okay. Any other questions for Mr. Day? Thank you, Mr. Day. Is there anyone here who wishes to be heard in favor of this appeal? Is there anyone who wishes to be heard in opposition to it? Please come forward. You swear to tell the truth and nothing but the truth. Please.
Name's Norm McCoy. I'm a butter to Mr. Day.
Norm McCoy.
That's correct.
What would you like us to know, Mr. McCoy?
First off, I own property up there, and the trailer is quite visible from my yard. It's been there since the middle of June. There doesn't seem to be much going on with as far as the building of the property that looks like maybe it will be there. Also, I've noticed in the evening, Mr. Day seems to be there overnight. I own 45 acres right across the road from him. Also, it affects the value of my land and my property because there's a trailer there, and it is, as it says in the letter that I received, it's zoned RO. So my understanding is that there shouldn't be a trailer there. Am I correct in assuming that?
You can
Not
put
exactly.
it in your backyard.
Huh?
You can put it in the backyard.
In other words, if
I
there
thought
were
they
a
had-
house there, then he could park the RV there.
Yeah, but I'm talking about right now.
No, right now, that's why he's here. It's
That's
not
why he-
allowed.
Sorry.
There doesn't seem to be much headway being made as far as a house being constructed. he's owned the land, since last fall, I believe. So it just decreases the value of my property. If I want to subdivide my land and make it into building lots, and try to sell building lots, and there's a trailer across the street, I don't think I'm gonna have much luck trying to, sell that.
How would you feel about him being allowed to keep it there until his house is built, say, 1 year or less?
I'd be in opposition to that. It's been there for 2.5 months, and, like I say, I don't see much construction being made, as far as a house being built. I've checked with Ms. Netto, over at, City Hall. There's been no permits issued whatsoever, he said.
Well, we did hear testimony that he hasn't pulled a permit yet. He's working
Okay.
on his septic permit. So
Okay.
we understand what you're saying is true.
Okay. And like I say, I just don't see much progress being made over there. I'm not against him building a new house, but when somebody moves a trailer in and it just takes away from my property.
Okay,
And
I think we've covered that ground. Thank you
Yeah.
very much.
I guess I just want to, yeah, I guess I've covered pretty much all of it.
Very good, thank you.
Yeah.
Is there anyone else who'd like to be heard in opposition to this appeal? Is there any comment from code enforcement? Mr. Day, would you like to offer factual clarification in response to anything that you heard? You'd have to come up and...
Other than the fact that the only reason why he's here is what
Come on up,
Wait till you're up.
so we get you on tape and all that good stuff.
So the only reason why he's here is when I first bought the land, I had gotten my timber permit to cut down the trees. I had barely enough room to get my truck on the land, and obviously where I was cutting off the rest of the trees, I didn't want my vehicles there. My mother would bring me lunch and park across the street. So on my side of the street, there's a 3-foot embankment, so she couldn't clearly park off the side of the road past the white line. So there, I know as a contractor, like there's a 15-foot right-of-way on normal sides of the streets or something for, emergency purposes. So she was parking on his side of the street, which technically isn't his land. But he decides that he's gonna come over and give me and my mom crap, like my mom got in an argument with his wife just because we were parking on
This
that
is,
side.
this is,
That's why he's
I'm
here.
sure, very stressful for you, but it doesn't bear directly on our decision.
Right.
Thank you. With that, we'll declare the public testimony portion of the hearing closed. We have a application for a variance to permit the parking of a recreational vehicle on a lot without a house, which is not permitted in the RO zone. We heard testimony that the appellant plans to build a house and that he would like to park the recreational vehicle there until he does have the house built, at which point it becomes legal, assuming it's no longer in the setbacks. Nick, what do you think?
Well, we did something similarly back in March, and not only did we do that, but we also granted a variance to a front setback requirement. So I think I'm in favor of the plan as submitted.
For a period of time, or?
For 12 months.
For 12 months, okay. At the end of 12 months, well, if that turns into a motion, we'll talk about the details. Jim?
Yeah, I agree with everything that Nick said.
Laura?
I want to agree. I think there's a difference between what the board did in March, where there was already a house, there was construction issues happening, there was delays, if I'm not mistaken, if I'm remembering that wrong, tell me. This is someone who wants to pull a permit, who wants to build a house, that is in the process of getting a septic approval and then wants to do everything else, but isn't in that stage yet. my concern of granting this variance contingent of 12 months, if no permits are ever pulled in 12 months, regardless of his good intent, things happen, then we've just allowed a trailer to sit on a piece of property to be worked on and stored for 12 months. We've denied other variances for other properties where they said we want to have a storage trailer for storage, and we said no to them. And as much as I empathize with the applicant and feel for him, he's trying to build his equity and work hard and build a house, I don't feel he meets the burden of proof for the variance, and I'm going to have to vote no.
Andrew?
Yeah, I mean, and that Hull Street, I'm sorry, that Hope Avenue case, that was specifically under 2892, which is a specific element of the code that authorizes us to issue a temporary permit for a specific reason when a house has been made uninhabitable and they're reconstructing it. But I think here, I don't think we have the authority to issue a variance for only a year. I think the general rule, as I understand it, is the variance runs with the property. I mean, we've limited it to, scope, but I don't think that I can recall, have limited it to time. So I just don't think we can do that.
Okay. I am inclined to, I guess I'm in Laura's camp on this one. I would love to say yes, but I can't see a justification under the ordinance for doing it. It doesn't meet the criteria for a variance, and it doesn't meet the criteria for an extraordinary situation with a damaged building or a building that's half constructed and so forth. So, although I definitely see the appellant's point, I'm not sure we have the grounds to grant in this case, so I'm going to be inclined to support a motion that to deny. Would anyone care to make a motion either way?
I move to deny the variance.
Is there a second?
I second.
Discussion.
So, if it was a construction trailer while he was building his house connected to temporary service, would you have a different view on it?
If the house were under construction, yeah, I might. But that's a different part of the ordinance.
It's a different section, and again, we've denied a very similar case where someone wanted to put storage trailers on a property without a structure.
Yeah, I'm distinguishing it because the representation is that it's just on a temporary basis for 12 months. No, if we're not able to,
Right.
no one's guided me in this, if we're not able to issue a temporary situation, then.
My argument wasn't about the temporariness of it. Mine was it's. Yeah.
That's how I look at it.
Yeah.
I look at it slightly different from them. I mean, if we could issue a temporary, I just don't think we can, to my knowledge. I don't think we've ever, like on a use variance, I think I've heard this come up a lot, like someone says, oh, I'm just gonna use it to cut hair or to, groom dogs or whatever for 6 months until I can buy my own, a more better shop, and I think we've denied on, in those instances. To me, that's somewhat comparable.
Yeah, it's probably a discussion for another day, but the more I think about it, the more the idea of issuing temporary approvals is inconsistent with the intent of the ordinance, I think. Because if it's a bad idea, it's a bad idea now, and it's a bad idea six months from now in terms of what the ordinance is trying to accomplish.
Would we consider this if you'd actually started construction? Look at it in a different light?
I don't know. That's a counterfactual that I can't answer the question really. If it were brought to us under the aegis of a temporary structure while construction is underway, as was the Hope Avenue one.
Right, that's not what he's doing.
Then we'd be looking at a different kind of case, I think. Here, in principle, it's really no different than the one on Lock Road. Much as I'd like it to be different, as I see it anyway. We have a motion, we have a second, I believe, did we? So I'll call for a vote. All those in favor?
Aye.
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 Opposed?
Nay.
Nay.
The vote is 3-2. The variances, the motion was for both variances, correct?
Yes.
Are denied. The next case is case 4621, David Keller. The applicant wishes to build a 7-foot, 3.5-inch by 19-foot storage addition onto an existing garage carport structure and requests variances to the table of dimensional regulations to permit a structure to be located 2 feet plus or minus from the front property line where a 25-foot setback is required, and Article 28.4.1H, Table of Dimensional Regulations, to permit a structure to be located 14 feet 9 inches plus or minus from the easterly side property line where a 15-foot setback is required, for property located at 8 Cody Street in an RM medium-density residential district. Mr. Keller, you swear to tell the truth and nothing but the truth.
I do.
Would you identify yourself for the record as you testify, please?
David Keller, 8 Cody Street, Concord.
Would you fill us in on why you feel the variance is appropriate?
Sure. So, you all probably know that the longer we live, the more stuff we accumulate.
I've noticed that.
Until you reach a point where it's time to downsize, and I'm a few years ahead of that. So I thought it'd be nice to add to my existing garage on the left side as we're looking at it here, a storage space for bicycles and lawnmowers in the summertime and motorcycles in the wintertime. Hired a contractor, drew up some plans, submitted them here, and discovered that they were within the setback. I discovered for the first time that my driveway is city property, but the city has so far not come to plow it in the wintertime. So this was, that red line there is the, I think that's city property, and you, to meet the variance, or the easement code, you gotta go back another 25 feet. So in other words, the garage and the carport are already grandfathered into where, to be non-conforming to the current regulations.
So is your driveway, which is your driveway in this picture?
So the driveway is basically from here to here.
Ah, I see.
The garage, this would take you into the garage, this is a carport.
I see, I see.
Over here is where this addition would go.
So your garage and your carport are right on the property line?
Correct.
I see.
Surprise to me.
And that was a surprise.
Your driveway runs parallel to the street?
No, well,
There's sidewalk
It's
there, right?
perpendicular
I think
to
what
it.
you're seeing in this picture is a car parked right here.
Oh, I see.
Okay, so all of this is asphalt driveway.
Oh, I see.
Or what you thought was your driveway?
Well, yes.
Where's the street on that? I can't, I'm having problems with colors, so I can't.
This is Cody Street.
Okay.
And
I'll come out a little bit and see if that helps you.
Okay.
There we go. The different colored pavement, there we go. Shading.
I'm partially colorblind, so it makes it.
So, when we found out that building this addition would require a variance, initially, the contractor and I suspended the idea. But a few weeks later, I was walking on, what's the name of the street? Joffrey Street, 2 blocks south, and discovered a 2-car garage being built there, clearly within the setback. And I brought that to the attention of the planning board. They said, yep, that particular, or no, the people downstairs, I'm not sure who but that property got 3 variances. So I thought, well, let me submit a variance. Maybe it'll work. So that's where we're at this point.
Okay.
I have a letter from the neighbor who lives here, which is the only person that received one of the letters from here that would actually see this addition. And he said he's totally in support of it, sees no problem.
Would you pass that over to me?
Sure.
Thank you.
I've talked verbally with my other neighbors, and nobody sees any problem with it, but again, his is the only property that would actually even see it.
Very good. Questions for Mr. Keller? 7 feet is the width of the shed?
Yep,
Off the side of the existing garage?
that's correct.
The length of the garage?
19 feet.
Okay.
So it would basically go the whole length of the garage, pretty much the same way that the carport goes on the east side.
Right. Okay. Questions for Mr. Keller? No?
It's a flat, it's a flat piece of property, there's no grade.
Yes, that is correct.
Is that a shed sort of in the,
Yes, it is, and that's a shed on cinder block, and I was told when I bought the house that that was kosher because it's not a permanent structure.
is that, but you have
I don't know about kosher, but there it is.
Yeah, there it sits.
It's not in the ground, so.
they had a rabbi come out.
Yeah, right.
So is that a whole lot? You have a really big lot.
Yes,
right?
I do.
Can you put a shed somewhere, out there?
It would be really inconvenient because it wouldn't have a driveway to support it. It would, technically yes, but it just would be sort of in the wrong.
Or you want it to be against a driveway so you can bring
Much more
stuff in and
convenient
out
to
of it.
have the shed be there, and much less obtrusive to the fact that that's a fairly nice, large lawn.
Right. Yeah, it's a very nice.
So you must store a lawn tractor.
What's that?
You must store a lawn tractor.
I still push my mower.
Okay.
Are you needling the chair?
I mean, my son and I both own motorcycles, and we have to drive them to storage in the wintertime. This means they can just go right there, and we're all set.
Very good.
Seemed like a good idea at the time.
Other questions for Mr. Keller? Thank you very much.
All right.
The record will show that there is no one present to testify either in favor or in opposition. I do have a letter here. I'm the neighbor of David Keller at 12 Cody Street in Concord, New Hampshire. From our vantage point, we would likely be the most affected by the proposed plans to expand his garage towards our property line. We have no issues with the planned expansion he has requested. This is from Matthew Gaffrere. He doesn't give his address, but I assume he lives on Cody Street as well. Comments from code enforcement?
None, sir.
With that, we'll close the public testimony section of the hearing. We have a request for a variance to add a shed to the side of existing garage. We heard testimony that there really is no other place that isn't in violation of the setbacks that such a structure could be constructed. Andrew, what do you think?
I'm sort of deliberating.
You want to deliberate some more, and I'll go to Laura?
Yeah.
Okay. Laura, what do you think?
Sorry.
I understand Andrew's concern. It is a large piece of property. There are other locations, but the use of what the applicant wants makes sense to have it adjacent to the road, adjacent to a driveway. You can't put motorcycles up in the back corner. I guess you can go cross-country with it, but I think that it won't harm the neighborhood, it won't have a negative impact. And again, I'm sure he was surprised realizing that his existing structures are right on the property line, so I'm in favor of it.
Jim?
Yeah, I agree. I think there's a uniqueness given the fact that, well, maybe it's not all that unique, that the property line is right at the structures. It's no fault of the property owner, so. So anyway, I agree with Laura.
Nick?
Yeah, the encroachment is 2 feet on one setback and 3 inches on the other one. Minor encroachment, so I'm all in favor of it.
Andrew?
Yeah, in looking at it, I'm not as concerned about the setback up against the road because that setback is already infringed upon in an equal manner. It hasn't caused any issue. The other setback problem is so close and doesn't seem to be concern for the neighbors. So I agree.
I'm inclined to agree with all my colleagues. I think the asking him to move it over to the other side of the yard would actually be a poorer use of the property. It really damage its appeal overall rather than improve it, and I don't see that to be the benefit of the neighbors or part of the intent of the ordinance. And clearly, he was bushwhacked by the code here. When the ordinance was passed, I doubt, when that building was built, I doubt that any of this was the case.
There was no rabbi involved in it?
The rabbi was not, if he was present, he was not paying attention. All right. Would anyone care to make a motion?
I'll move to approve.
Is there a second?
I'll second.
It's been moved and seconded. Is there discussion? All those in favor?
Aye.
Aye.
Anyone opposed? The vote is unanimous. The variance, was it one variance or two? Two variances are granted. Do I hear a motion concerning last month's meeting minutes?
So moved.
Is there a second?
Second.
Been moved and seconded. All in favor of approving the meeting minutes, say aye.
Aye.
Anyone opposed? Any other business for us this evening?
I don't know if we have minutes. Or What you
That's what
just
they
said.
just
I'm
did.
sorry. No, I was watching,
We were so quick.
I was looking for Ernie to
Yeah.
come back, but
I'm a gunslinger when it comes to minutes.
all set, you're good. Thank you. Nothing from code. Sorry if I missed a couple questions there, but I'll,
All right.
You got to get your skates under you on this stuff. I'm not criticizing you on
Nope.
it. It takes a bit to do it. I
He's got
am
a
really
lot
glad it's not my
going on this
job.
week.
We talk fast, we're confusing.
oh, that part.
We
I
don't
just
have a
meant to-
clue.
I said, a lot going on I'm happy Ernie's accepted a position and we'll get there.
Yeah. That first case was a
So we can turn off the
Strange.
recording?
Yeah.
And we
Turn
turn
off the recording.